11th order. The House is at the 11th order. The House will now have under consideration House Bill 196. Good lady from District 6.
Thank you, Mr. Speaker. House Bill 196 amends existing law to revise.
I ask unanimous consent.
I request unanimous consent to dispense with further reading of House Bill 196.
You've all heard the unanimous consent request to dispense with further reading of House Bill 196. Is there an objection? Hearing none, the good lady from District 6 is recognized to open debate.
Thank you, Mr. Speaker. This bill amends existing law to revise provisions relating to the timing of permitted Idaho premium tax offsets by member insurers. It makes minor wording changes in two guarantee association laws to allow the traditional interpretation regarding the year in which the offset can begin to be taken to continue as it has in the past. It deletes a subsection that was duplicated, and it's deleting the duplication paragraph. There's no change in the amount of any tax or the tax offset as the result of these amendments, and we're not aware of any opposition to the legislation. I ask for your yes vote.
Is there further debate? Hearing none, the debate is closed. The question is, shall House Bill 196 pass the House? The clerk will unlock the machine and the members will cast their votes. Have all the members voted? Representative Agidius, how do you vote? Representative Chu votes aye. Representative Agidius votes aye. Representative Wood, how do you vote? Representative Wood, 35, votes aye. Does any member wish to change his vote? The clerk will lock the machine and record the roll. The roll call shows 69 ayes, 0 nay, 1 absent and excused. House Bill 196 has passed the House. Is there correction to title? Hearing none, House Bill 196 will be transmitted to the Senate. The House will now have under consideration House Bill 199. The gentleman from District 34.
Thank you, Mr. Speaker. I would ask unanimous consent to dispense with the reading of House Bill 199.
You've all heard the unanimous consent request. Is there an objection? Hearing none, the good gentleman has the floor.
Thank you, Mr. Speaker and members of the House. This bill pertains to self-funded health care plans for private universities. And the two universities in Idaho that this would affect is BYU Idaho and Northwest Nazarene University. And it allows them to set up their own health care plan to fit the requirements of their own students in those universities. It's a good thing. It's something, though, that we had to do through the Department of Insurance so that the department could set up the rules and regulations for them, that they could administer the funds that were put together and set out how much had to be in reserve and how the funds would be administered within the universities. It's just for universities that have 800 students or more in that university. This was requested because there's a lot of interest in our universities, not only those but state universities, which this plan does not affect, state-run universities, but for them to be able to take care of their students and take care of their students under their own principles that they have. It's a good bill. They had to do a lot of other work with this particular code section due to it being quite an old section, and the Legislative Services went through it and found a number of things that they had to update language. For example, the old bill says financially viable alternatives to traditional health care arrangements. Arrangement is not a word that's acceptable to them now, so that all through the plan is crossed out and put in place as plans. So it's not arrangements anymore, it's plans. and it goes through here a number of places. It identifies the Department of Insurance in a number of places that it didn't before. Another place it says no person shall offer or operate self-funded plans in this state, and then they struck out except while and put in unless the plan is. So there's a lot of language in here that was corrected by the Legislative Service. Another place it says self-funded plans shall have power, struck out power and put in the authority. So don't have power anymore, you have authority. So these are a lot of correctional things that were put into this bill. It's quite lengthy, and they had to go through the whole thing to make these typographical, I don't know whether typographical, but these kind of corrections to the bill so that it would correspond with current language. With that, Mr. Speaker, I would like to defer to the other gentleman from District 34 who would go through and explain what this plan does and then take questions.
Will the gentleman from District 34 yield?
Gentleman yields.
The gentleman has the floor.
Thank you, Mr. Speaker. Some of the pertinent items that were not mentioned was that, first of all, we talk about a self-funded health benefit program. It is not an insurance company, nor does it follow under the insurance regulations, which is why we had so many pages that had to be amended. This falls under a special situation, which I can say that the Federal Health and Human Services Department readily likes these programs, as long as they meet the minimum requirement for OPACA or PPACA. And so this is something that's going to be very well received. It's going to take literally tens of thousands of our students off the potential Medicaid rolls because they can afford health insurance very cheaply. For example, the current plan at one university is $270 a semester per student, which is a great deal. For a married couple, $317 per semester. So these plans are very affordable. They have relatively low deductibles, and they're just a great program. One of the reasons, or perhaps the primary reason, that these two universities don't like it, Obamacare, is they require insurance companies to provide free contraceptives, which goes against their theology. And so this gives them an out, a way of establishing a health benefit insurance program for their students and maintaining their principles in life. One other thing I ought to bring out. On page 5, section 414003, lines 41 through 47, the Idaho Life and Health Guarantee Association is not encumbered by this plan. So if a plan defaults, there's no encumbrance upon the state of Idaho to make up for the losses. It's a good program, it's good for the students, it's good for Idaho, and we ask for your support. Stand for questions.
Is there further debate? Hearing none, the debate is closed. The question is, shall House Bill 199 pass the House? The clerks will unlock the machine and the members will cast their votes. Have all the members voted? Representative Miller, how would you vote on this? Representative Miller votes aye. Does any member wish to change his vote? The clerk will lock the machine and record the roll. The roll call shows 66 aye, 4 nay, 0 absent, excused. House Bill 199 is passed the House. Is there a correction to title? Hearing none, House Bill 199 will be transmitted to the Senate. The House will now have under consideration House Bill 124. Good lady from District 29.
Thank you, Mr. Speaker. I ask unanimous consent that we dispense with further reading of House Bill 124.
You've all heard the request. Is there an objection? Hearing none, the good lady is recognized. Open debate.
Thank you, Mr. Speaker. And members of the House, House Bill 124. This bill comes from Pardons and Governing Rules. and it asks for to amend Section 20-223 of the Idaho Code. The purpose of this proposal is to clarify the time frame in which requests can be made for remission of bond monies within 1 year from the date of discharge of the offense for which the offender was serving parole. This modifying the statute will reduce the state's obligation to remit bond monies, with the exception of those that have requested same within the specific period of time, thus allowing for the state to capture and direct these funds toward extradition costs. Additionally, this modification would allow the state to discern monies on hold pending request versus monies that are no longer obligated to requesters and are solely for the purpose of extradition costs of parole violators. No physical impact at this time. This bill passed committee unanimously, and I would ask for a yes vote, Mr. Speaker.
Is there further debate? Hearing none, the debate is closed. The question is, shall House Bill 124 pass the House? The clerk will unlock the machine and the members will cast their votes. Has every member voted? Representative Packer. Representative Clow, how do you vote? Does any member wish to change his vote? The clerk will lock the machine and record the roll. The roll call shows 70 ayes, 0 nay, 0 absent and excused. House Bill 124 is passed the House. Is there correction to title? Hearing none, House Bill 124 will be transmitted to the Senate. The House will now have under consideration House Bill 212. Oh, excuse me. 214, excuse me. House Bill 214, good gentleman from District 16.
Thank you, Mr. Speaker. I ask unanimous consent that we dispense with further reading of House Bill 214.
You've all heard the unanimous consent request. Is there an objection? Hearing none, the good gentleman has the floor.
Thank you, Mr. Speaker. Ladies and gentlemen of the House, House Bill 214 is a bill relating to adoptions and putative fathers. And I want to stop there and explain, for purposes or in the context of this bill, what a putative father is. It is a father who claims to be a father or who is alleged to be a father with respect to a child who was born out of wedlock. The bill touches on several titles and chapters of the Idaho Code and clarifies statutes in Idaho governing adoptions. It reduces the chances that an adoption will be unwound or declared invalid, as has occurred on 3 different occasions in the state of Utah last year, which has statutes similar to those in Idaho, which emphasize doing it fast rather than doing it right. Recognizing that the potential for litigation and unwinding adoptions in Idaho was present for us, the Department of Health and Welfare, through the Division of Family and Community Services, put forward this legislation. The bill contains 3 main substantive changes and a couple of other changes that I'd like to discuss. First of all, it requires the putative father to commence proceedings to establish paternity within specific deadlines, within 10 days of the birth of a child. And if the father cannot prove by clear and convincing evidence that it was not possible for him to do so, and if he did not file with the putative father registry maintained by Vital Statistics prior to birth, and it's through no fault of his own, then he does have the 10-day period in which to establish paternity. But if he does not, or to initiate the proceedings, excuse me. But if he does not take those actions within that 10-day period and commence his action to establish paternity, then it is deemed that he is consenting to any adoption that the birth mother may agree to. Consistent with current law, lack of knowledge of the pregnancy is not an acceptable reason for failing to comply with statutory timelines. The division tells us that these provisions are constitutional, and the division further tells us that they are necessary to assure that adoptions that are done properly and that they stick. Nothing is worse than having a child placed in an adoptive home only to find out a matter of weeks, months, or in some cases years later that the adoption has to be undone. Imagine the effect on the child when that occurs. Because our adoption laws, like Utah's, seem to favor quick over what is right, we are at risk for having similar disruptions in our state. This legislation has been in the works for over the last 5 years. The latest iteration is the result of collaborative work done by the senator from District 33, David McCroskey, General Counsel for the LDS Church, Willie Dennert, an adoption attorney in Idaho Falls, and Stan Welsh, a domestic relations attorney in Boise. Meetings were held with the Idaho Supreme Court on 2 occasions, once with the magistrate judge's legislative review team and once with a group of judges who sit on the Child Protection Subcommittee. If the bill is passed, it will accomplish 4 things. It will further the best interests of the child. It will clarify that putative fathers must strictly comply with the law. It will establish a date certain for putative fathers to comply with the law. And it will direct the Department of Health and Welfare to produce and distribute a pamphlet explaining the law in this area. Further, it will reduce the chances that adoptions will be unwound. Mr. Speaker, I'd like to yield the balance of my time to the good gentleman from District 15.
Will the gentleman yield?
Gentleman yields. Thank you,
Gentleman has the floor.
Thank you, Mr. Speaker, members of the body. Good representative from 16 has outlined some of the legal details on this. I would like to just address a few policy considerations. When a young woman is faced with a pregnancy, there's a difficult choice if this is outside of wedlock. One is to either keep the child or the other is to put it up for adoption. A third option is to have an abortion. What this bill is designed to do is to encourage young women to allow that child to be born and have a secure home after the birth. And a lot of what goes into that decision is an assurance on the part of the birth mother that legal matters are in order and that these adoptions won't be unwound. And so the purpose behind this is to encourage life, to encourage stable family homes for those situations where there is a child that is born out of wedlock and the mother decides not to keep the child. This only applies when the child is going to be put up for adoption. And so it's incumbent upon the husband, or not the husband, but the putative father, to step forward and show some interest in this child before that date and to show a commitment. Otherwise, the process is to allow this child to be adopted into a home that can provide all of the needs, the love, the financial, the parental support that a child needs, as we know is the case these days. So this is an important bill. It is important to allow a placed child to not be pulled away from adoptive parents once that adoption has taken place. Thank you.
Is there further debate? Good lady from District 5.
Thank you, Mr. Speaker. Would the gentleman from 16 yield to a question?
Will the gentleman yield?
Gentleman yields.
The gentleman yields.
Thank you, Mr. Speaker, and good gentlemen. I would just like to be sure I'm tracing this sequence of events correctly. So if you have a baby conceived out of wedlock and perhaps because of circumstances the mother of the baby never informs the father, and later she puts him up for adoption, and after that, the father learns of his relationship with this baby, he would have forfeited any of his parental rights. Is that how it works?
Gentleman from 16.
Thank you, Mr. Speaker. Good lady. That could be the case in some scenarios. There is a putative father's registry, and if the birth were recorded in that registry, and if the putative father took action within 10 days because he learned of the situation through the putative father registry, that would be a variance on the scenario that you've sketched out.
Could I follow up, please, Mr. Speaker?
Will the gentleman yield further?
Yes.
Gentleman yields.
And so, in order for that to work, though, he would have to gain that knowledge within 10 days.
Gentleman from 16.
Thank you, Mr. Speaker. Good lady, that is correct.
Thank you.
Is there further debate? Hearing none, the debate is closed. The question is, shall House Bill 214 pass the House? The clerks will unlock the machine and the members will cast their votes. Has every member voted? Representative Lurcher votes aye. Does any member wish to change his vote? The clerk will lock the machine and record the roll. The roll call shows 67 aye, 3 nay, 0 absent, and excused. House Bill 214 has passed the House. Is there a correction to title? Hearing none, House Bill 214 will be transmitted to the Senate. Good gentleman from District 14.
Mr. Speaker, I'd ask unanimous consent that the next bill, House Bill 206, be placed on the third reading calendar below House Concurrent Resolution 10.
You've all heard the unanimous consent request. Is there an objection? Hearing none, so ordered. The House will now have under consideration House Bill 220. Good lady from District 11.
Thank you, Mr. Speaker. I ask unanimous consent that we dispense with the further reading of House Bill 220, please.
You've all heard the unanimous consent request. Is there an objection? Hearing none, the good lady has the floor.
Thank you, Mr. Speaker, and good afternoon, House members. We haven't met in the afternoon yet. So it's my honor to present House Bill 220 to all of you, and it's a bill intended to maintain Idaho's equine industry in our great state. Idaho is reported to have the highest rate of horses per capita than anywhere else in this nation. Overall, the equine industry in Idaho amounts to approximately a $1.2 billion economic impact to our great state. And horse racing alone has an estimated $15 to $20 million impact to our state's economy. And so this industry is worthy of our best effort and support. As technology develops, our businesses and industry must embrace new technology and be able to incorporate it into their business models in order to survive in a rapidly changing environment. House Bill 220 specifically seeks to allow Idaho's horse racing and equine industry to do just that, to incorporate new technology into their business models, which will allow them to survive, stay competitive, especially with our neighboring states such as Wyoming, which has very recently passed a similar bill, and ensure sustainability in the years to come. Technology now allows for a new form of parimutuel wagering, which is already allowable in Idaho, called historical horse racing. House Bill 220 is designed to encompass this new technological form of racing in Idaho by doing two things. It amends existing Idaho Code 542502 by adding the definition of historical horse race. And secondly, it adds a new section to Idaho Code 54-2512A. This section delineates the arenas whereby historical horse racing can proceed. Currently, there are only 3 horse tracks in Idaho, one in each major geographical area of the state. The section also outlines the breakdown of funds, which are split between various entities, such as the participants, the Idaho State Racing Commission, Track Distribution Account, Breed Distribution Account, the Idaho Horse Council Youth Program Account, and the Public Schools Income Fund. The monies generated by this bill will be used to maintain the horse training and racing tracks, as well as generate funds for racing purchases, which will allow the industry to be sustainable in Idaho. Also, funds are used to enhance our youth programs, such as the Idaho Horse Council and Youth Program, which helps to support the FFA and 4-H programs in each district across the state. Idaho treasures its $1.2 billion horse racing and equine industry, along with its vast array of agricultural and business partners. It is an important cultural way of life that we must protect. There is no known opposition to this bill, and in fact, there is a long list of supporters, such as the Horsemen's Benevolent and Protective Association, D&B Supply, the Idaho Horse Council, and the 2.5 pages of supporters from all around the state that you have on your desk before you. And with that, Mr. Speaker and members of the House, I would like to ask for your support in green light.
Is there further debate? Good lady from District 18.
I rise just to say that I need to declare, what is it called, a rule of 38. My family has horse racing, I'll do this right in a minute, has racehorses, and I do intend to vote. Thank you.
Duly noted. Is there further debate? Good gentleman from District 23.
Thank you, Mr. Speaker. Would the lady from 11 ask?
Would the good lady from District 11 yield to a question?
The lady yields. Thank you.
The lady is yielded.
Thank you very much. Now, when this rebroadcast of old races is what I'm understanding here, and how many places in Idaho is this rebroadcasted to, where the center's going to be, where the people can get together and look at the horse race, wager a bet and all that kind of stuff? Where's all this going to be conducted?
Good lady from District 11.
Mr. Speaker and good gentlemen, where this is conducted is currently where simulcast racing already takes place, and there are 3 places across the state, one up in northern Idaho, one in eastern Idaho, and Les Bois Park right here in Boise.
Follow up, Mr. Chairman.
Will the lady yield further?
Yes, Mr. Speaker.
The lady yields.
Then I've been told some misinformation, because I was under the understanding this would be put forward into many, many places where there are pinball machines and et cetera, things like that, but it won't have any conflict with any of that then.
Lady from 11.
Mr. Speaker and good gentlemen, no, it won't. It can only take place in the 3 places that have simulcast racing, and simulcast racing is actually a very heavily regulated industry here in Idaho, and the Idaho Racing Commission falls under the purview of the Idaho State Police.
One more follow-up, Mr.
Will the lady yield further?
Yes, Mr. Speaker.
Lady yields.
I'm a little bit surprised that the satisfaction or the need to be able to bet on horse races is not satisfied with live horse races. And I'm wondering where all of this desire and this need really has come from, and who is actually doing the betting, what class of people, and who are those that are actually being involved.
Lady from 11.
Mr. Speaker and good gentlemen, I think the demographics would actually surprise you. Demographically, it happens to be actually people over the age of 55 and predominantly women.
Is there further debate?
Thank you, Mr. Speaker.
Thank you, Mr. Speaker.
Further debate? The gentleman from District 22.
Thank you, Mr. Speaker, and good ladies and gentlemen. I debate in opposition to this bill. I really don't think we need to start expanding gambling by going to old horse races and rerunning them and figure out who's going to win and try to figure out. We already know who won before it's broadcast, just the person watching it doesn't know. And I really don't think, and even though some of my main competitors are on this list of supporting it, I guess I would rise in opposition to this bill. I think we got enough gambling rather than going to the old horse races and rebroadcasting races we know.
Is there further debate? Gentleman from District 23.
Thank you. Possibly to debate against it, not possibly I am.
The gentleman has the floor to debate.
Thank you, Mr. Speaker. I'm not sure how this follows the temperance rules that are in our Idaho State Constitution, but to me, gambling is gone far enough in this state, and this is just opening the door for a little bit more of it. And I'm sorry it's little old ladies that do most of it, but my wife's not involved. Thank you.
Is there further debate? Gentleman from District 2.
Thank you, Mr. Speaker. I rise in support of this bill. I was in the committee, and I was surprised to realize just how expensive it is to raise these horses and to train these horses. And this certainly is gambling. We have some issues with gambling. We certainly need to limit that and regulate that. And I appreciate the fact that the Racing Commission is involved in this. But the idea that the horse raisers and trainers in this need another flow of income, it to me is extremely important. I myself spent some time in Oaklawn Park in Arkansas where this originated, and I grew to appreciate the work and the time put into these horses, and just to keep this industry alive is extremely expensive. So those that enjoy horse racing and enjoy betting on them should be allowed that. It's not like we have, it's totally illegal in the state to bet on horses. This is just another stream of revenue, and I think would greatly help the industry in itself, and of course jobs for the state. So in that reason, I think we should support this bill.
Is there further debate? Hearing none, the good lady from District 11 is recognized to close the debate.
Thank you, Mr. Speaker and members of the House. If I could address one issue that I do know is bothersome to some people, and Mr. Speaker, if I can have permission to read from the Constitution.
The lady has always has permission to read from the state's Constitution.
Thank you. Just to clarify.
Without permission, even.
Oh. Thank you. Just to clarify, Article 3, Section 20 of the Idaho Constitution says, gambling prohibited. Gambling is contrary to public policy and is strictly prohibited except for the following. A state lottery, which is authorized by the state if conducted in conformity with enabling legislation. And B, parimutuel betting if conducted in conformity with enabling legislation. And C, bingo and raffle games that are operated by qualified charitable organizations in the pursuit of charitable purposes if conducted in conformity with enabling legislation. And I would just like to clarify for the House that what we're talking about actually falls under the purview of parimutuel betting, and the Attorney General's office has looked into this certainly before we brought the bill. So what I'd like to tell all of you really is that this bill was brought to us by people who are all very committed to the equine industry and its agricultural and business partners. I have been so impressed, actually, by all of them. They've recognized a problem within their own industry and the impact that it would have on their lives and the lives of many others who are entwined with Idaho's economy. These people are independent, forthright, hardworking, and very capable people. And they came to the legislature with a recognized problem, and they brought a solution in hand. It is a solution that was research-based and data-driven and has been proven to be very successful in other states. And they look to seek to maintain and sustain their industry here in the state of Idaho. It certainly has been my honor and a privilege to represent them in their endeavors, and I hope that it'll be your honor and privilege to support them as well. So we would all like to ask you at this time to please give your support and green light to House Bill 220. Thank you.
The debate is closed. The question is, shall House Bill 220 pass the House? The clerk will unlock the machine and the members will cast their vote. Have all the members voted? Does any member wish to change his vote? The clerk will lock the machine and record the roll. The roll call shows 58 aye, 12 nay, 0 absent, excused. House Bill 220 has passed the House. Is there correction to title? Hearing none, House Bill 220 will be transmitted to the Senate. The House will now have under consideration House Joint Memorial Number 1. Good gentleman from District 32.
Thank you, Mr. Speaker. I ask unanimous consent to dispense with reading of House Joint Memorial 1.
You've all heard the request. Is there an objection? Hearing none, the good gentleman has the floor.
Thank you, Mr. Speaker. This joint memorial is about the Frank Church Wilderness and the Frank Church Wilderness of No Return. This joint resolution, this House Joint Memorial, urges the Secretary of Agriculture and the Chief of the U.S. Forest Service to take note of the dire conditions prevailing in the Frank Church River of No Return Wilderness. It further urges prompt emphasis and priority to be placed on practical, immediate actions to address those conditions and prevent further cumulative losses of unique values in this, the largest wilderness in the western United States. It specifically urges the compliance with the letter and spirit of Section 5, subparagraph B of the Central Idaho Wilderness Act of 1980. And I shall quote from that, if I may. The Secretary shall, to the maximum extent practicable, consistent with the management plan required by this section, clear obstructions from all of the natural forest trails within and adjacent to the wilderness at least an annual basis. What has happened with the recent fires we've had in the Frank Church Wilderness, the Forest Service has closed several trails in there, making the use of the trail system dangerous at best and sometimes totally impractical. So this resolution memorial, this joint memorial, encourages the Secretary of Agriculture, the Secretary of the Forest to comply with the Wilderness Act and get in there and service those trails and reopen them to where they may be used by the folks of Idaho. As you may know, the Frank Church Wilderness is the largest wilderness in the lower 48 states. It's 2.25 million acres. It has 2,500 miles of trail systems. And obviously, it has 2 world-class rivers in it. And currently, the trail system is not being maintained to the satisfaction and use of backcountry horsemen, guides and outfitters, and other recreationalists who use that area. So with that, Mr. Speaker, I'd encourage your yes vote that we may encourage the Secretary of Agriculture to and the Manager of the Forest Service to comply with their requirements to clean these trails annually. Sir, Mr. Speaker, I'd further request a roll call vote on this. Thank you.
Roll call vote will be had. The gentleman from District 19.
Mr. Speaker, to debate against the bill.
Gentleman has the floor.
Mr. Speaker, members of the body, I originally voted for this in committee. And as you all know, I am an outfitter. I'm actually a wilderness guide. I have nearly 2,000 days in the field as a guide. And as someone else in this body told me when I first came into it, being outside has given me the skin cancer to prove it. In fact, I've done significant trips in the Frank Church Wilderness. I've decided to change my vote for 3 reasons after thinking about it. The first was, after I voted for it, I received some emails from some river guides, which I am, although I don't own that. I'm a mountain guide. But they're very similar. Being a guide is a laborious and difficult job. We employ 77,000 people in Idaho and generate $461 million in state tax revenue every year. Declaring the Frank Church Wilderness area a disaster zone is bad for business. Additionally, wilderness by definition, in 2010 I received the Wilderness Education Association's Instructor of the Year Award. Wilderness by definition is characterized by 4 traits. Untrammeled, which means an ecological system free of the effects of civilization. In this case, fire is part of an ecological system. My issue with this bill is not that the Forest Service is not doing its job in accordance with the Central Idaho Wilderness Act, because it isn't. But my issue with it is that it blames fire for the problem. When I worked at Boise State, I was hired by Gordon College to take a group 30 days into the wilderness. Gordon College is an evangelical Christian school. We spent several days in a burned out area south of Missouri Ridge. They did their theological studies in this burned out area, specifically talking about death and dying. There is value to wilderness. The second is undeveloped without permanent improvement or modern occupation. As fires rage through the Frank Church, it's part of the process, and we are losing structures back in there as the fires rip through. But again, the idea is to not replace those, to let it return to a natural ecological system. And last is primitive. Regulations against human behavior. There are organizations that would like to get into the Frank Church wilderness, specifically mountain bikers. I understand that. We have a lot of open space. Agriculture, ranching, and recreation can exist together. And the wilderness, the Frank Church in particular, is the heart of wilderness areas in Idaho. One last thing. Having friends that work for the Forest Service, this bill holds the Forest Service accountable. Even as a Democrat, I cannot miss the opportunity to take a shot at the federal government. The House subcommittee that is responsible for appropriations to the Department of Agriculture has not done its job. The Forest Service has received a 1% increase since 2004 in terms of budget. And here comes the sequester. My challenge with the sequester is I can travel in the backcountry. I can get clients through the backcountry. And the sequester is a way bigger issue. The other day, this student from a school in Meridian was interviewing me. And in interviewing me, he said, "Do you associate politics with your identity?" And it caught me off guard because I thought it was came out of left field. And I closed my eyes and I thought of myself with a harness, a rope, and a scared client. And I was able to say, no, I do not identify myself as a politician. I identify myself as a mountain guide. And so with that, I've chosen to vote no for this. Thank you.
Is there further debate? Good lady from District 8.
Thank you, Mr. Speaker. In support of the bill, and briefly, I don't want to see too many of us end up in left field and not knowing really what's going on here. But the Frank Church Wilderness of No Return is in Custer and Lemhi counties, which are still currently in my legislative district. So I know whereof I speak because people come to me about issues regarding wilderness. The Frank Church Wilderness of No Return, or whatever it is, we just call it the Frank. But anyway, the Frank Church Wilderness has largely become the Frank Church Wilderness don't show up because you can't go see anything anyway. There are no trails. That is the responsibility of the Forest Service. They have not been able to maintain that responsibility, either voluntarily or involuntarily. And if they can't do it, then they ought to give it back to us, and we'll do it. This is just a House concurrent resolution. What we are saying to the Secretary of Agriculture, and I think it needs to be done. I also know the forester that was involved in putting this together. Know him personally. He's a good man, and he worked for the Forest Service. He's retired, so he knows whereof he speaks. We need to get those trails open. It needs to be used by the people who live there and those who visit. Thank you.
Is there further debate? The gentleman from District 8.
Thank you, Mr. Speaker, good members of the body. I also am from District 8, and I must also include Valley County as part of the Frank. Most of all the largest wilderness in the lower 48 is contained in District 8. This is a home that the good lady from 8 and I both know well. Having served on the RAC, which is Resource Advisory Committee, as a state representative from, and the RAC, which advises the Forest Service on how to move forward with some projects, we've looked at many trails, and they are having a serious problem. And this serious problem is not getting the attention in Washington, D.C., and it needs to be brought to the front burner, and this concurrent resolution will do that. Those trails out there are a true disaster. This year alone, this fall, the RAC put forward $300,000 that's going to Forest Service projects, which are mostly done by volunteers, and most of this money goes to support. But that, again, is coming through the counties to the RAC and back to the Forest Service because they aren't capable or able to do their job. And I do not understand why they do not include in their proposal when they utilize black money. Black money is what they receive after a fire for restoration. And for some reason, these trail systems get ignored. And they were to be maintained and left open for the public. They're violating their own ADA requirements by not keeping our trail systems open for the public. I very much encourage your support for this House Joint Resolution. And again, I will point out that this was brought to us by former Forest Service supervisors who are very frustrated with what they see today. Thank you.
Is there further debate? Hearing none, would the good gentleman from District 32 care to close the debate?
Thank you, Mr. Speaker. Just a couple of quick points. The joint memorial does refer to the wilderness as a disaster area, a potential disaster area. That may be harsh language, but the point we're trying to make is we're trying to make a point. These memorials are going to have little value other than to make a point with the Forest Service and the Department of Agriculture that we need some action there. So we thought that harsh language was justifiable. Secondly, there is, I don't think, anyone that is advocating that the Frank Church Wilderness ever be open to bicycles. That simply is not a matter of debate. I don't think anybody that was involved in the committee hearing would advocate that in any form. And lastly, we did speak in the memorial as to whether or not different techniques could be used to help clear the forest trails. One that was mentioned is a wheelbarrow. Well, certainly a wheelbarrow is a primitive instrument. It was the early Egyptians had wheelbarrows, I guess 8,000 years ago or so. So that was kind of where wheels came to play as to whether or not we were talking about the use of wheels, and that led to bicycles, and we're not advocating bicycles. I would also point out that when there's a log jam on the river, they use dynamite to blow the log jam out and clear the river. So we clear the river of debris with dynamite, which certainly is, I don't know how primitive it is, but it's a man, it certainly didn't exist in the wilderness. So with that, I think this is a good memorial. Encourage some action in the Frank Church, and I encourage your green light. Thank you.
The debate is closed. The question is, shall House Joint Memorial Number 1 pass the House? The clerk will unlock the machine and the members will cast their votes. Has every member voted? Representative Barrett. Does any member wish to change his vote? The clerk will lock the machine and record the roll. The roll call shows 57 aye, 13 nay, 0 absent, excused. House Joint Memorial Number 1 has passed the House. Is there a correction to title? Hearing none, House Joint Memorial Number 1 will be transmitted to the Senate. The House will now have under consideration House Concurrent Resolution Number 6. Good gentleman from District 6.
Thank you, Mr. Speaker. I ask unanimous consent to dispense with the reading of House Concurrent Resolution 6.
You've all heard the request. Is there an objection? Hearing none, the good gentleman has the floor.
Thank you, Mr. Speaker. This resolution recognizes a problem of prescription drug abuse and encourages an Idaho response. Prescription drug abuse has become an epidemic in the U.S. and in Idaho. It's a leading cause of ER visits for drug overdoses and has climbed only behind alcohol in lethality for Idahoans. There are many facets to this disease. Patients with chronic pain or addiction, prescribers who are hurried in their practice or may be unfamiliar with patients in an ER or urgent care setting, dispensing pharmacies not selective in their filling habits, families that have narcotic medications at home, and adolescents who believe that prescriptions are safe. Add to the fact that there's a large market on the street and in schools for the drugs and a marketing promotion for the use of pain medication, and it's little surprise the problem has grown. 1 year ago, in response to several deaths of young people from overdoses of prescription narcotics, we started a work group involving the boards of medicine, nursing, pharmacy, the medical and hospital associations, law enforcement and prosecutors, community drug prevention advocates, and others to discuss the issue and begin to develop recommendations. Senator Schmidt and Representatives Perry, Chu, and myself were involved as well. The Office of Drug Policy, Alicia Figueroa, took over leading this effort after the session. And since then, we've made some improvements. First, the prescription drug monitoring database of the Board of Pharmacy has been modernized, staffed better, and become easier to use. In addition, they're being proactive in informing practitioners and prescribers of aberrant prescription use patterns. The Office of Drug Policy led the development of a media effort on locking away or destroying medications and has been endorsed by the Millennium Fund Board for financial backing for this effort. The licensing boards are more aware of the harm and are approaching the professions with more training and greater scrutiny. But there's still a lot of work to do, and this resolution recognizes the critical role that licensing boards and law enforcement has and instructs the Office of Drug Policy to continue a lead role in this work group. Thank you, Mr. Speaker.
Is there further debate? The gentleman from District 23.
Thank you, Mr. Speaker. Would the gentleman from 6 yield? Question.
Will the gentleman from District 6 yield to a question? The gentleman yields.
Thank you, Mr. Speaker. Gentleman from 6, I'm not saying this is a bad idea, but what I'm asking is why aren't we adopting statute and policy to cause this to happen, that they should be doing it anyhow? These
gentleman,
are Idaho agencies that we're talking about.
Gentleman from 6.
Thank you, Mr. Speaker, and good gentleman. There was a proposal to adopt statute, for example, that would limit the amount of narcotic prescription or to require that a practitioner would need to document that they had checked the prescription drug database. That, however, that bill would have only taken one slight view of this multifaceted issue, and really was felt by some of the practitioners in the hospitals and the medical association as being counterproductive. It would tend to drive people out of the treatment of pain, and that the patients then would go and find narcotic medications on the open market rather than through the practitioners. So this is a very complex and difficult problem. There are a number of states that have had some successful efforts, including and some that are trying things that are more drastic. Washington, for example, has a prescription protocol that physicians and emergency rooms can only prescribe a limited amount. We had discussed whether we should make it a matter of licensing, that prescribers check the prescription drug database prior to filling a prescription. And it may eventually come to that from the boards of medicine, nursing, and dentistry. However, at this time, we're into this less than a year, and I think we've had some good results as far as interventions that can be done, first to make the database useful and accurate, and secondly, to encourage through the licensing boards its use.
Mr. Speaker, a follow-up, please.
Will the gentleman yield further?
Yes, gentleman yields.
The gentleman yields.
Thank you, Mr. Speaker. Gentleman from 6, then, what you're suggesting to me is these folks are going to get together and they'll make rules, regulations that we will see next year to help us in this work, or are they just going to study the issue, so to speak?
Gentleman from 6.
Mr. Speaker and good gentlemen, this body has no rulemaking authority. The various boards do have rulemaking authority. Prosecutors can, of course, change their policies, as can law enforcement. What this group will do is come up with a series of recommendations, as they have already. Their first recommendation was make the database work, get us an extra person They are to handle and prepare reports, disseminate the reports out to the practitioners so they know beforehand. Those are recommendations that the work group has already made, and they will continue to make recommendations. They may well recommend that the Board of Medicine or the Board of Pharmacy or do rule changes, or that we as the legislature consider statutory changes. But unless you have those things viewed from a on a broad basis, squeezing it here may just make it worse over here. And that's the purpose for the work group, is to get as many of the players together and come up with an integrated solution.
Thank you.
Is there further debate? Good gentleman from District 34.
Thank you, Mr. Speaker. Would the good gentleman from 6 stand for a question?
Will the gentleman yield?
Gentleman yields.
Gentleman yields.
Good gentleman from 6. The SOP says there'll be no fiscal impact. I'm wondering where the funds are going to come from to enlarge this program, do the monitoring, and you said develop new methods of tracking and everything else. Where's the money going to come from to do that?
Gentleman from 6.
Mr. Speaker and good gentlemen, the people that participate in the work group are already participating in the work group. There is no increase. We did last year add an FTE to the Board of Pharmacy for the management of the database and preparation of these reports. So that is not an addition to the budget this year. There is no travel expense. These are all volunteers who do this and do by telephone. So there is really no expense to this work group.
Okay, thank you.
Is there further debate? Good gentleman from District 14.
Thank you. With the good gentleman from 6 yield to a question, please.
Will the gentleman yield?
Gentleman yields.
The gentleman yields.
My concern has to do with the fact that we're opening up this database to lots of new organizations, health and welfare, local governments. What do we have in place to make sure that that there's no HIPAA violations, as well as the fact that someone in a county office doesn't just decide to get on the database and find out what medications their neighbor is on? What protections do we have in place for this?
Gentleman from 6.
Thank you, Mr. Speaker and good gentlemen. This database has been existing in an electronic format since 2007. There are security protocols. You have to register with the Board of Pharmacy and then get an identification number. Each entry is tracked, and that's why they can see which practitioners have checked the database prior to a prescription, because they know who came in and entered. It is a protected database. It is available to law enforcement. It is available to the Board of Pharmacy, and it is available to a practitioner in a limited manner so he could see if a patient has gotten multiple prescriptions.
Is there further debate?
Just a follow-up.
Will the gentleman yield further?
Gentleman yields.
Thank
gentleman
you.
Yields.
So from a procedural standpoint, what does law enforcement have to do in order to access this database to assure that there isn't a HIPAA violation that's taking place?
Gentleman from 6.
Thank you, Mr. Speaker, and good gentlemen. They have to go to the Board of Pharmacy and get the record from the database. They have to be acknowledged and get a access number. And by HIPAA, it can only be used for either health plan operations, and it can be used for criminal prosecution. Those are the HIPAA exceptions.
Thank you.
Is there further debate? Good lady from 11.
Thank you, Mr. Speaker. I simply rise in support of this resolution. I would just like the body to know that myself and several other members here volunteered our time for a year on this particular project, and I was shocked at the amount of information that came in. You would be shocked at really what a problem prescription drug abuse is here in the state, not only in regards to adults, but especially to our kids and in school, and how simple it is for them to clean out their grandparents' medicine cabinet, take it to school and sell them. It's really quite an interesting problem, and it sounds very simple, but from what we listen to, it is an extremely complicated issue as well. And so I certainly find the need to continue with what we have been doing here, and we're really looking for a broad idea-based solution group rather than someone kind of trying to piecemeal things, as often happens with legislation. This one is actually to be a very concerted effort with all the stakeholders involved, so that when legislation comes to the body, we really truly know that this was the right way to go. So I would certainly like to ask your support on this. Thank you.
Is there further debate? Hearing none, would the good gentleman care to close?
Thank you, Mr. Speaker. I'll close briefly. This is a good idea to keep working on this. We have a lot of volunteers that can use the encouragement of the legislature to go forward working on this problem. Thank you.
Debate is closed. Since this resolution does not expend money, there being no objection, there will be a voice vote. Hearing none, the question is, shall House Concurrent Resolution 6 pass the House? All in favor say aye. Aye. All those opposed say nay. Motion passes and House Concurrent Resolution is passed the House. As a correction to title. Hearing none, the title is approved and the concurrent resolution will be transmitted to the Senate. The House will now have before it House Concurrent Resolution 12. Good lady from 19.
Thank you, Mr. Speaker. I ask unanimous consent to dispense with the reading of House Concurrent Resolution 12.
Unanimous consent has been requested. Is there objection? Hearing none, the good lady has the floor.
Thank you, Mr. Speaker, and good members of the House for your consideration of HCR 12, a resolution that recognizes the sesquicentennial year of the City of Boise. As you all now know, the City of Boise joins the Idaho Territory, which celebrates its sesquicentennial anniversary today, March 4th. This resolution recognizes Boise's rich history, beginning prior to its original platting in 1863. Some of these items include the Northern Shoshone Tribe, early 19th century French-Canadian explorers, and the 1862 Boise Basin Gold Rush. The City of Boise was then founded with the platting of its original 10 blocks on July 7th of 1863, and now this city, the capital of the great state of Idaho, celebrates its 150th anniversary in the year 2013. The City of Boise Arts and History has planned an array of events throughout 2013 to celebrate the city's rich history. You can check out the Boise City's Sesquishop on Main Street, historical markers throughout the city, and finally the city's Boise 150 celebration on July 7th to celebrate its 150 years. So in partnership with the office of Boise's Mayor David H. Beater, I ask for your blessing to send this resolution to the Senate with full support. Thank you for your time, and I stand for any questions.
You've heard the motion. Is there further debate? Hearing none, debate is closed. The question is, shall House Concurrent Resolution 12 pass the House? There being no dollars spent on this concurrent resolution, there'll be a voice vote without objection. Hearing none, the question is, all those in favor of House Concurrent Resolution 12 say aye. Aye. All those opposed say nay. The motion is passed and House Concurrent Resolution 12 is passed the House. As a correction to title. Hearing none, the title is approved and the concurrent resolution will be transmitted to the Senate. The House will now have before it House Concurrent Resolution 8. Good gentleman from 20.
Thank you, Mr. Speaker. I'd ask unanimous consent not to read House Concurrent Resolution number 8.
Unanimous consent has been requested. Is there objection? Hearing none, good gentleman has the floor.
Thank you, Mr. Speaker. This resolution is to recognize the achievements that the Idaho's Transportation Department has had. It's real easy for us as legislators. We come to town and we hear about all the problems with departments. It's real easy for us to call these departments up and complain a lot. Not very often do we get the opportunity to tell them they're doing a good job. We have those opportunities, but we don't take them often enough. And I'm especially guilty of that. So today I'd like to be able to recognize ITD for the things that they've done. I'm not going to go through and read it, but just one of the things mentioned in the HCR is the fact that how much money they have saved by reorganizing how they do their management. They've saved millions of dollars, and they have yet in the last 3 years to come asking for more money. The time will come when we do need more money for transportation, but it's not because of the management and the waste of money. They take really good care of the people's money, and I, for one, appreciate it. As soon as I was put into my current position in the transportation, my phone number is out there in the public, and I started receiving these phone calls, and I got some real interesting complaints about the department. One of them was their trucks were too dirty. I thought, okay, well, if that's what you would complain. Another one was their trucks were too clean. I thought, okay, so we can go either way on these. It just seems like sometimes we get a little bit carried away with the complaints and need to recognize these people for the good things that they do and the example they set. Hopefully, other departments can look to the example of ITD and see the type of management that they do in their management team and maybe move forward with some other places and be able to save some money. And I would encourage your green vote for this. Thank you.
You've heard the motion. Is there further debate? Good gentleman from 1.
Thank you, Mr. Speaker.
Just quickly, if we're going to do these resolutions in recognition of agencies, I hope that the agency is listening currently, because as much as I do appreciate and acknowledge the many efforts that they've put forward to better their department, there are still many things that they have failed to do up in the northern part of Idaho, and I hope that they are listening to this vote today. I know it'll be a voice vote, but there's not satisfaction across the board with some of my constituency.
Is there further debate? Hearing none, would the gentleman from 20 care to close?
Good bill should pass.
Since House Concurrent Resolution 8 spends no money, without objection, there'll be a voice vote. Hearing none, all those in favor of House Concurrent Resolution 8 say aye. Aye. Those opposed say nay. The House Concurrent Resolution 8 has passed the House. The ayes do have it. There's a correction to title. Hearing none, House Concurrent Resolution 8 has passed the House and will be transmitted to the Senate. House will now have before it House Concurrent Resolution 10. Good gentleman from 6.
Thank you, Mr. Speaker. 2 years ago, this legislature instructed the Health Quality Planning Commission in HCR 39 to examine stroke systems of care and make recommendations. That was because evidence was presented that Idaho had a greater number and disability from strokes than the U.S. as a whole. During the year-and-a-half investigation, it was discovered that we not only have problems dealing with stroke, but other time-sensitive emergency conditions. We do not have an organized manner of dealing with them. These conditions, which include trauma, stroke, and heart attack, are 3 of the top 5 causes of death in Idaho and have a higher fatality rate and disability rate than would be predicted given our population. They also discovered that a defined trauma system was the backbone for time-sensitive emergency care. Attempts in the past to develop such a system were stymied by concerns about local hospitals being left out and bypassed for larger facilities. Evidence was presented this time that a comprehensive system involving everyone from the community to trained and qualified EMTs to coordinated transport and clinical services and all levels of hospital, improve outcome, lessen disability, and actually lower cost than such care when it's unorganized. Based on the research, the Health Quality Planning Commission suggested that Idaho develop a system of care for these time-urgent conditions. This resolution calls on the Department of Health and Welfare to develop a trauma plan that can be used to organize time-sensitive emergency services throughout Idaho. Mr. Speaker, as this was studied, it was presented that the EMS Bureau and the Department of Health and Welfare has staff, and they also have grants available to provide for this, and therefore it has no fiscal note.
Thank you, good gentleman. You've heard the motion. Is there further debate? Good lady from 35.
Thank you. Would the gentleman from 6 yield to a question?
Gentleman from 6 yield.
Gentleman yields.
Gentleman yields.
I might ask the question, is this in place of the trauma center or the trauma gathering information that I think we already have?
Gentleman from 6.
Mr. Speaker and good lady, we have a trauma registry.
That's what I was saying.
And that is a record of what happens with the EMS. The trauma system is broader than that. It goes from pre-emergency care, so people learn what the systems of stroke or heart attack are so they know to call for help, all the way through the care from first responders, through the transportation, as well as the facilities in our state that provide care for those critical injuries in the first hour or so when it's necessary to preserve life. So this is bigger than a registry. A registry is a component of it.
Thank you.
Is there further debate? Gentleman from 23.
Would the gentleman from 6 yield?
Gentleman 6 yield.
Gentleman yields.
Gentleman yields.
Thank you, Mr. Chairman. Gentleman from 6, I'm a little bit concerned about what it says on the second paragraph of the statement of purpose, well, the third paragraph, and it says that the broad community involvement together with professional expertise to develop a plan for this care and to present draft legislation to the 2014 legislature if appropriate. Now, I'm a little suspicious. Is this draft legislation and the idea of this proposal to help coordinate efforts to support an Idaho insurance exchange?
Mr. Speaker and good gentlemen, no, it is in no way involved with insurance or payment whatsoever. It is for the delivery of critical care services for those situations, stroke, particularly trauma, but also stroke, heart attack, that an improved system of care and more rapid delivery of care will improve the outcome and the health of Idahoans. It is in no way related to insurance coverage.
Gentleman 23.
Thank you. Just in response, ladies and gentlemen.
Gentlemen, are you debating the bill?
No. A statement, if I may.
The gentleman is debating the bill. The gentleman has the floor.
Okay. Thank you, Mr. Speaker. The gentleman from 6, I have a great deal of respect for this fellow. He answered me forthright, and I'm going to take him at his word, and thank you.
And we'll call that debate in favor of the bill. Is there further debate? Hearing none, since there was no negative debate, debate is closed. Since House Concurrent Resolution does create a working group, the Speaker is going to rule that we'll do a roll call vote. It says there's no fiscal impact, but the working group, somebody's got to pay for that. So the clerk will unlock the machines and the member will record the roll. Has every member voted? Does any member wish to change their vote? Clerk will lock the machine and record the roll. 66 ayes, 1 nay, 3 absent and excused. The majority having voted in favor of House Concurrent Resolution 10. House Concurrent Resolution 10 has passed the House. This is a correction of title. Hearing none, the title is approved and the concurrent resolution will be transmitted to the Senate. Good gentleman from 13.
Mr. Speaker, I think we've worked the troops pretty hard today. Probably time to let them go, so I'd ask unanimous consent that we hold the remaining bills on the third reading calendar one legislative day.
Unanimous consent has been requested. Is there objection? Hearing none, the remaining bills on the third reading calendar will hold their place one legislative day. Without objection, the House will return to the fifth order of business. Report of standing committees. The House is at the fifth order of business.
March 4th, 2013. Mr. Speaker, will your Committee on Judiciary Rules and Administration report that we have printed House Concurrent Resolution 6 and House Bills 242, 243, and 244. Will's Chairman.
House Concurrent Resolution 16 will be filed for second reading. House Bills 242, 243, and 244 will be referred to Revenue and Taxation Committee.
March 4th, 2013. Mr. Speaker, will your Committee on State Affairs report that we have had under consideration House Bill 120 and report it back with amendments attached to be placed on general orders for consideration. Lurcher, Chairman.
House Bill 120 will be placed on general orders. Without objection, the House will now advance the 15th order of business announcements. The House is at the 15th order of business. Are there announcements? Good gentleman from 22.
Thank you, Mr. Speaker, and good ladies and gentlemen. The Idaho Transportation Department will once again be here at the Capitol tomorrow to take your pictures to issue a legislative ID. And I might remind those who have been breaking the camera to please get to the back of the line so the rest of us can get our picture taken. And there's no appointment necessary. Just go down there and get your picture taken. Thank you.
Are there further announcements?
Oh, question was where? Room 17 on the west wing.
Thank you, good gentleman. Are there further announcements? Good lady from 26.
Thank you, Mr. Speaker. The minority party will have a brief caucus meeting immediately following the adjournment.
Are there further announcements? Good gentleman from 27.
Thank you, Mr. Speaker. Just want to remind the body that the Bulldogs of Gonzaga University are ranked #1 in the nation. Thank you.
Easy there. Good gentleman, 13.
Thank you, Mr. Speaker. Just want to remind the body it's our intention to go into general orders tomorrow afternoon. So if you have any amendments, we need to get those to Bonnie by 5 o'clock today.
Are there further announcements? Hearing none, clerk may read.
Following are the Standing Committee meeting announcements for this afternoon. Agricultural Affairs Committee will meet upon adjournment, East Wing, Room 42, Andrus, Chairman. Environment, Energy, and Technology Committee will not meet this afternoon, Raybould, Chairman. Local Government Committee will not meet this afternoon, Barrett Chairman, and Transportation and Defense Committee will meet this afternoon upon adjournment, Palmer Chairman. For tomorrow morning, Education Committee will meet tomorrow morning, Tuesday, March 5th at 9 a.m., East Wing, Room 41, DeMordaunt Chairman. Health and Welfare Committee will meet tomorrow morning at 9 a.m., East Wing, Room 20, Wood Chairman. Revenue and Taxation Committee will meet tomorrow morning at 9 a.m., East Wing, Room 42, Collins Chairman. And State Affairs Committee will meet tomorrow morning at 8:30, Lurcher Chairman.
Are there further announcements? Hearing none, the House will advance the 16th order of business adjournment. The House is at the 16th order of business. Good gentleman from 13.
Thank you, Mr. Speaker. I move the House to now adjourn until 10:30 a.m. Tuesday, March 5th, 2013.
Mr. Speaker, I second the motion.
Thank you, good gentleman. You've heard the motion. All those in favor say aye. Aye. Those opposed say nay. The motion passes and the House will be adjourned until the hour of 10:30 a.m. Tuesday, March 5th, 2013.